Welcome to Trusts and Estates Weekly. I'm your host, Kevin Bemmel, and we're here every Monday at 10 a.m. Pacific time. That's 1 p.m. on the East Coast. Of course, for those of you on the East Coast, you already know that. And we talk about all things related to probate, trusts, estates, both from the standpoint of planning one's estate or helping people plan their estate, to the administration of a trust or a probate, and how all of those things work. So today I'm going to indulge a little bit and talk briefly about the history of probate. I think it's a good idea to know, how did we get to where we are today, and why does the system work the way that it works? So I did this week I did put together a PowerPoint, which I haven't done for a while, and we're going to jump right into it. So this is, like I said, a brief history of probate. So as is always the case on the Way to Wow shows, they all revolve around the concept of the three pillars of attainment. And on this show in particular, we're dealing usually in the finances realm of the pursuits pillar, but of course it gets into relationships as well, and oftentimes our identity, as we're figuring out what kind of legacy do we want to leave behind. So the history of probate goes back thousands of years into ancient Egypt, and we see there that back in the time of the pyramids, if you will, even back then they had written wills. Now, they were written on papyrus, not on paper, which wasn't around yet. But nonetheless, it was the Egyptian society was a very advanced society. I mean, when you consider the engineering marvels of the pyramids. I was watching a video about this not too long ago, and these multi-acreage sites are so flat that the difference in level is I think less than 3 centimeters. That's roughly 1.2 inches. I mean, that's an amazing grading, especially for such a huge site. So we're talking about a sophisticated society. The library at Alexandria was probably the largest repository of information in its time. And so it shouldn't be any surprise that this idea of someone creating a written document that spelled out to whom his property would go upon his death goes back all the way to that time. So you can see how old it is. Now, for those of you who are familiar with the Bible, of course, there are biblical rules about inheritance. Those don't necessarily relate to probate. They deal more with who is entitled to get a decedent's property. So they deal more with heirs. But there were issues like that floating around, both in the what's sometimes called the Mosaic Code, the rules that are in the Hebrew Bible, as well as the Code of Hammurabi. So there is thousands of years of history behind probates and the process of distributing assets upon the death of the owner. So in ancient Rome too, the concept of wills existed. You had a testamentum. Okay, that is Latin for a will, and you've undoubtedly heard the term last will and testament. So you can see where the term testament itself comes from. And then you had the familiae emptor. Now, this is not caveat emptor, a completely different topic, but familiae emptor is what we would call in English an executor. So you can see it's the representative of the family, basically. Again, it's in Latin, and so you had in the testamentum the appointment of the familiae emptor. And that has, Rome. We're dating back now, around 2,500 years or so. And you can see that that this concept of having someone appointed to administrate the will is also a millennia old practice, going back all the way to that time. So these concepts were bouncing around for quite a while. As we move into the Middle Ages and into the feudal system, so the concept of primogeniture came up, and you saw this. Now, this is different than the biblical concept. So, according to the Old Testament or the Hebrew Bible, if a man had, let's say, 4 sons, okay, and under the biblical system, if a man had sons, daughters did not inherit. So the oldest son, the first son, was entitled to a double share of the estate. So let's say he had an estate that included 1,000 sheep. Okay, so it wouldn't be divided up 250 among each of his 4 sons. Instead, the first son would get a double share, so he would get 400, and the other 3 sons would get 200 each. Okay, but you can see that all of the sons did inherit. Now, under the system known as primogeniture, the oldest son, the firstborn son, hence the word primo, right? First, he inherited the entirety of his father's estate. Okay, now, what happened as a result of this is sometimes a difficult situation. So let's take that same situation where a man had 4 sons. Okay, now, if you were the first son, you were in the catbird seat, right? And you were destined to inherit your father's entire estate. Now, by the way, if he had, let's deal in England. If he had a title, let's say he was a duke, or maybe he was an earl, so that son would also inherit the title. Okay, and the other sons would get nothing. Now, if you were number 2 son, well, you probably are going to hang out pretty close to home just in case. One of my friends is watching, and she says she's glad to know that she and her younger brother will inherit the same number of sheep. Yes, indeed. Um, so under the feudal system, so the second brother is going to stay pretty close to home, because if the firstborn son dies, so he's next in line, so he's going to end up inheriting the entire estate. Okay, so he's going to hang out close to the older brother. Now, you might note that he has kind of an incentive to do away with his older brother. And while I can't cite a specific case, it is undoubtedly the case that at times, a younger brother, a second brother, did away with his older brother in order to get the title and the estate. Now, if you're number 3 or number 4 brother, well, so what are the chances that 2 of your brothers are going to die? Or in the case of the 4th brother, 3 of them are going to die. So, you're in a situation where you're either going to end up basically having to, rely on your oldest brother to support you, or you've got to go find some other way of making a living. And oftentimes, and I've spoken about this a little bit before, but oftentimes what these 3rd, 4th, etc. brothers would do is they would either get a career, and usually especially in the Middle Ages, that meant either joining the clergy, or it meant joining the military, becoming an Army or a Navy officer. Okay, and in that way, they could gain respectability by the nature of the work that they did, because they weren't going to become a tradesman, especially if they were a member of the aristocracy. But by becoming a member of the clergy or an officer in the armed forces, so they had a position in society, and then typically their brother would give them an allowance in order that they could maintain their position, similar to a member of the family. But since they were doing something worthwhile with their lives, so it was a good idea to do that. Another thing that happened is these third and fourth brothers would look to marry well, as the term went. So if a man did not have sons, so then his daughter would inherit. That's true both. excuse me. Excuse me. Both. That's true both biblically. So, according to, again, the Mosaic Code, if a man had no sons, then his daughters would inherit. Okay. So you might have a situation where a young woman inherited her father's estate. Okay. And so then this third or fourth son would seek to marry her, because in doing so, typically he would gain control of the money. Okay. Even though it wasn't legally his, but he would gain the right essentially to manage his wife's estate. Okay. It was, especially in the Middle Ages, extremely unusual for a woman to manage her own property, especially a young woman. First of all, typically women were not taught what they needed to know to do that, and second, oftentimes they were not given much of any kind of education at all, and third, it was socially frowned upon, if you will, for a woman to be in that position, and that continued for centuries. Okay, so you can imagine that if this third or fourth or et cetera son was unscrupulous, he could steal money from or steal the estate from his wife, and indeed that did happen. Now we're talking about the English basis for probate law. In this Spanish world, the system was different, because they were more concerned about that issue. So throughout the Middle Ages, you saw things happening according to the feudal system. Now, eventually, the ecclesiastical courts took over the probating of estates. Okay, so ecclesiastical courts were the courts connected to the church. Okay, and they would oversee the probate of an estate, which included, first of all, the validation of wills. So really the first step in the probate of an estate, and this is true even today, is the validation of the will, meaning determining if indeed a will is valid. So, for example, I handled a case not too long ago where a person died intestate, meaning, or he appeared to have died intestate, and then a document was found, and there was an extensive discussion as to whether this document constituted a will, in particular, what's known as a holographic will. So in this particular case, the will had been word processed. Okay, and because of that, and by the way, what was found was a copy of a word processed document. It may have even been a typewritten document, but in any event, it was not handwritten. Okay, and so a determination was made that this did not qualify as a valid will. So, although there was discussions about trying to get it validated, in the end, it was certain the court would have rejected it, and so the intestate deceased was essentially the direction that the probate took. Okay, and then the other thing that ecclesiastical courts did was they oversaw the appointment of executors and administrators. Now, typically, a will would appoint an executor. That's the person in the will appointed to administrate the estate is known as an executor. Now, back then, if it had been a woman, she would have been known as an executrix. Okay, they distinguished between the sexes of the person appointed. Now, if for some reason the person designated as the executor in the will could not serve, let's say maybe he had predeceased the decedent, or maybe he was incapacitated, maybe he was mentally incapacitated. Okay, so now he's not fit to act as the executor, in which case the court would appoint an administrator. Okay, and the heirs to the estate might put forward someone to be the administrator, or the court might choose someone. They might choose a lawyer. They might choose, a member of the clergy. It really depended on what the ecclesiastical court judge thought would be in the best interest of the estate. Now, you may be wondering, well, wait, why did probate end up in the ecclesiastical courts? And a lot of the reason is because, as I was mentioning before, the Old Testament especially has things to say about who inherits property, and so some of the source of probate law comes from the Bible. That's number one, and number two, probate was always, well, I don't want to say always. It was typically seen as what's called a matter of equity. So in the English legal system, there were essentially two different matters that would that over which people to dispute, what were called matters of law and matters of equity. So matters of law were also could be sometimes called a tort. It's when two people are disagreeing. Let's say, for example, one of your horses got loose and it trampled your neighbor's crop and destroyed part of the crop. So the solution to that would typically be a payment by the owner of the horse to the owner of the crops that were damaged. That's a matter at law. But sometimes money won't solve a situation. And so you need what was called equitable relief. Okay, so trying to think of an example of a case of equity. I had one in mind, and now all of a sudden it went away. Okay, so let's say that somebody is slandering you. Okay, now you may not have really lost any money as a result of being slandered. However, it's surely the case that being slandered is not a good thing, and so you would apply for equity, and in this case you would apply to have the person speaking the slander prohibited from doing so, and perhaps having to issue some kind of apology or some kind of recantation of what the person said. That would be a matter of equity. Now, in the Middle Ages, matters of law were overseen in courts. Matters of equity were overseen essentially by the aristocracy, the lord who had ownership over a particular portion of land. Okay, and so if one was suing at equity, one would essentially go to the Lord and say, Your Honor, or your Grace, if he was a duke or whatever, my Lord, or please, stop this person from doing this thing. Okay, now probate, even though it involved money, it didn't involve damages. And so probate was seen as a matter of equity. And so although originally during feudal times, the lord of the land would oversee the cases, as they got more technical, they were transferred to the ecclesiastical courts as being a more appropriate venue for dealing with the complexity. Okay, so now we go into more modern times. So in England during the 19th century, in fact, in 1857, the probate court was formally established. Okay, so you can see that's really only about 175 years ago did we have separate courts in which probates were heard. And the reason a separate probate court was established was because by the mid 19th century, probates had gotten so complex, the amount of money involved oftentimes was so large that it really took specialists to deal with the various issues. Okay, and the English legal system recognized that, and so they established those separate courts. And that continues until the present day. Now, in colonial America, much of our law, especially when it comes to the process of probate, is based on English law. However, each colony set up their own courts. And so there was never in the United States a national probate court. So unless a probate for some reason happens to be dealing with some kind of strange issue that is happening at a federal level, probate never touches a federal court in the United States. It all happens within the courts of the individual 50 states. Okay, and so just like in the colonies where there were distinctions on how things were handled by colony, that also persists until this day. And so, for example, if you were to probate, sorry. Anyway, so you will see these variations in the way laws are handled. In fact, we saw, if you watched the show last week, you saw that different states have different schedules of compensation for executors, administrators, personal representatives, and in fact, they use different names for that person. So here in California, we call them administrators. In other jurisdictions, it's called a personal representative. And so even just a small thing like that, you'll find differences. Okay, so now, you can have a situation where a decedent has property in more than one state, and if that is the case, in fact, a probate may need to be filed in more than one state in order to make sure that everything is handled correctly. Okay, and so then that takes us up to current times. So the 20th and 21st centuries. Okay, here in the United States, as I was mentioning just a moment before, the law varies by state. Okay, and I just gave you an example of that. Now, in order to bring greater uniformity to the probate process, the Uniform Probate Code was introduced in 1969. Okay, and it was basically a number of people got together from the various states, and they essentially hammered out a probate code, which is essentially a set of laws about how probates will be handled, that was intended to be adopted by each of the 50 states. Okay, it was not, let me be clear about this, it was not intended that the federal government would impose this code on the states, because the federal government constitutionally does not have the authority to do that. Okay, And since 1969, I think of roughly 2/3 of the states have adopted some or all of the Uniform Probate Code. Okay, but by no means all. Now, is this a good thing, bad thing? I mean, it's a thing, right? Um, for probate practitioners like myself, it would certainly make it easier, I think, that if all 50 states adopted the Uniform Probate Code. But the fact of the matter is, different states have different issues, and so it's probably not practical for it to literally be adopted exactly the same by all 50 states. Okay, so for example, here in California, one of our biggest issues is water, things like riparian rights and all of that. In fact, if you look at a set of books that represent the laws of California, the water code is contained in about as many books as I think the civil code is. It shows you how important that issue is here in California, right? And so inevitably, when dealing with property, in this case, real estate, because water is such an important issue here in California, it at times is going to have an outsized impact, potentially at least, on a probate. Whereas in another state where water rights may not be as important, so then it wouldn't, and so then there doesn't need to be as much in probate or dealing with it in probate is not going to be as big a deal. Okay, so I think there will always be some variations. And as well, here in California, even a small estate is likely to be, hundreds of thousands of dollars. Whereas in a Midwestern state where property values are not as high, so then a small estate could very well be truly a small estate. And so the fee structures probably need to be different, because the reality is, while the numbers are bigger here in California, the amount of work isn't necessarily greater. The liability for an administrator or an executor may be higher because of the higher values, but the amount of work is not necessarily. And so that's why, kind of overall, fees appear to be lower in California on a sort of, like on $1 million estate. Here in California, the fee is lower than it would be in a state like Alabama. In fact, I refer you again to last week's show where we talked about fees for administrating a probate. Okay, and so I think there will always be variations in order to accommodate the differences state by state. So another advance that we've seen just in the last, I think, couple of decades probably, is things like electronic filing systems, right? That's an internet innovation. And so now many times, you don't have to send someone down to the court to file a document. It can be done online. And in fact, I know here in California, you can access most, if not all, documents online. In some cases, there's a fee for doing so. But in any event, the ability to file documents online has made the process of probate much easier, and at least in theory, less expensive, because you're not having to pay for attorney services to take documents down to the court and all that kind of stuff. So that's probably the most recent change that we've seen in the probate process. And so there you have it. A brief history of the probate process, just to give you some background so you can appreciate how all of this works. We'll just go through the last one. So if you have any questions, these links will be in the show notes after the show posts. So feel free to send me, or post a comment or a question or a criticism for that matter. Or if it's something private, you can always send me an email. And if it's something that I have, knowledge of, I'll be happy to respond. If not, I will, suggest that you contact the appropriate professional. Okay, and then we just wrap up here. I think we just got the legal stuff. There you go. Bum, bum, bum. Okay, we'll take this down. And so that's a show for today. And hope you found it interesting. Hope you found it useful to have that background. And by the way, I haven't mentioned this in a while, but if you are not a subscriber to the show, maybe you're watching it for the first time, please do consider subscribing. Just click on that subscriber link right below the video and joining the rest of the subscribers we have. And that way you'll never miss an upcoming episode of any of my shows, which includes tomorrow at 10 a.m. Pacific time, business lessons from the military. We're going to be talking about speaking truth to power. This is a subject near and dear to my heart, and you'll find out why tomorrow. And then on Wednesday at 10 a.m. Pacific time is people making money. And I will tell you what the topic is because I forgot it. It is, yes, networking to get a job. So for those of you like me who read the Wall Street Journal, they had a big article about this on Saturday in the Weekend Journal, and I'm looking at it and laughing about it. So I want to talk about this issue because recently I've been talking to quite a few service members who are transitioning to civilian life, and I think this is the most important topic for anyone who is job hunting is this idea of networking. So we're going to talk about that on Wednesday. And then, of course, we'll be back a week from today with the next episode of Trusts and Estates Weekly. So thanks very much for tuning in. Hope you enjoyed the show. Wishing you a wonderful rest of the day. And signing off as I always do, Marie, you're my bell.